Good morning. I am Dr. Ritu Gupta, Faculty, National Law University, Delhi. In today's module, we'll discuss about National Company Law Tribunal and National Company Law Appellate Tribunal, their constitution and duties. Let us have a quick overview of the module. The module focuses on the constitution, powers and duties of the National Company Law Tribunal, which was earlier known as Company Law Board, and National Company Law Appellate Tribunal. This module would provide an overview of the whole framework of the functioning of the tribunals as has been provided under Chapter 27 of the Companies Act 2013. In this module, we'll talk about sections 407 to 408, which provide for the constitution and qualifications of president and members of the tribunal, while sections 410 to 11 state similarly for the appellate tribunal. Further, sections 412 to 18 would be discussed that prescribe the procedure for selection and removal, resignation, the term of the office and salary, etc. of the members as well as the president of the tribunal and appellate tribunal. The place for the tribunal is provided under section 419, and further we'll talk about section 420, which talks about the orders of the tribunal. Then section 424 that provides for the procedure which should be followed by the tribunal and the appellate tribunal. The second appeal which may be filed with Supreme Court, section 423 we are going to talk about, and then we'll discuss section 425 to 432 that provide generally for various powers of the tribunal and appellate tribunals. Now I would discuss the objectives of the module. The main objective of this module is to provide preliminary knowledge about the National Company Law Tribunal and National Company Law Appellate Tribunal, to apprise the students of the constitution and the powers of the NCLT and NCLAT. Moreover, by discussing the contents of this module, we would make students understand the procedure of filing appeals, etc., as has been prescribed under the Companies Act 2013. Now I would introduce you to the contents of the module. The new Companies Act confers powers on the central government to constitute National Company Law Tribunal and National Company Law Appellate Tribunal. These tribunals are quasi-judicial bodies that govern the companies which are functioning in India and administer the provisions of the Act. The present Act has replaced the earlier body known as Company Law Board (CLB). It would exercise almost similar powers that were being assigned to by the erstwhile Company Law Board. The constitution of one body, that is NCLT, has streamlined the administration of justice under the Act. It is intended to have greater expertise to adjudicate disputes more efficiently and expeditiously. The appeal from NCLT orders would lie with NCLAT. The second appeal may be filed with Supreme Court. The whole justice administration system has been made time-bound. The tribunals comprise of senior judicial and technical members, and these tribunals are not bound by the procedure as has been laid by the Civil Procedure Code 1908 and have the power to regulate their own procedures. These are to be further guided by the principles of natural justice, PNJs. Their orders are enforceable just like the decree of any court. Now let us discuss the constitution of National Company Law Tribunal, which has been provided under section 408. National Company Law Tribunal is a successor quasi-judicial body of Company Law Board. The central government is to constitute this tribunal that shall consist of a president and such number of judicial and technical members as may be deemed necessary. Such members are to exercise and discharge such powers and functions as may be conferred on it by or under the Act or any other law for the time being in force. Section 409 provides for the qualifications of President and the members of the Tribunal. The President shall be a person who is or has been a judge of the High Court for 5 years. To qualify for appointment as a judicial member, a person shall qualify any of the following. Can be a judge of a High Court, or it is or has been a district judge for at least 5 years, or has been an advocate of a court for at least 10 years. A technical member of the tribunal shall fulfill any of the following. He can be a member of Indian Corporate Law Service or Indian Legal Services, out of which at least 3 years shall be in the pay scale of Joint Secretary to the Government of India or equivalent or above in that service. A chartered accountant who has been in practice for 15 years, or a company secretary who has been in practice for 15 years. He should be a person of proven ability, integrity, having special knowledge and experience of 15 years in law, industrial finance, industrial management or administration, industrial reconstruction, investment, accountancy, labor matters or such other disciplines related to the management, conduct of affairs, revival, rehabilitation and winding up of the companies, or 5 years standing as a presiding officer of a labor court tribunal or national tribunal constituted under the Industrial Disputes Act 1947. Section 410 further provides the central government shall constitute an appellate tribunal to be called as the National Company Law Appellate Tribunal. It shall consist of a chairperson and members not exceeding 11. The central government shall notify such appointments. The appellate tribunal has to hear appeals against the orders of the tribunal. Further, section 411 states the chairperson shall be a person who is or has been a judge of the Supreme Court or the Chief Justice of a High Court. A judicial member has to be a person who is a sitting or retired judge of the High Court or judicial member of the tribunal for 5 years. A technical member has to possess the same qualifications as stated in the constitution of the tribunal. Section 412 provides for selection of members. The president of the tribunal, the chairperson and judicial members of the appellate tribunal are to be appointed with consultation of the Chief Justice of India. The members of the tribunal and technical members of the appellate tribunal have to be appointed on the recommendation of a selection committee. This selection committee shall consist of Chief Justice of India or his nominee, who will be the chairperson of the committee. Then we have the following members: Senior Judge of the Supreme Court or Chief Justice of a High Court, Secretary in the Ministry of Corporate Affairs, Secretary in the Ministry of Law and Justice, and Secretary in the Department of Financial Services, who is in the Ministry of Finance. Further, the Secretary in the Ministry of Corporate Affairs shall be the convener of the selection committee. The said committee shall determine its procedure for recommending persons as we have just discussed. However, no such appointment of the members of the tribunal or the appellate tribunal shall be invalid due to any defect or vacancy in the constitution of the selection committee. Now let us discuss the terms of office and salary structure. Section 413 to 414 provide for it. The president and every other member of the tribunal is to hold office for a term of 5 years from the date on which he enters upon his office. He shall be eligible for reappointment for another term of 5 years. The age of retirement would be 67 years for the president, while that of the members is 65 years. The salary, allowances and other terms and conditions of service of the members of the tribunal and the appellate tribunal would be prescribed under the rules. However, we have to see that it is provided further that neither the salary and allowances nor the other terms and conditions of service of the member shall be varied to the prejudice of those who have been appointed. National Company Law Appellate Tribunal, salaries, allowances and other terms and conditions of service of the chairperson and other members, Rules 2014, and National Company Law Tribunal, salary, allowances and other terms and conditions of service of the President and other members, Rules 2013, may be referred for the same along with the other rules, whatever rules have been drafted, and whenever these rules are framed by the concerned authority. Section 415 provides that if any casual vacancy arises in the office of the President or Chairperson or in his ability to act, the senior most member is to act until new appointment. If the Chairperson, the President or any other member wishes to resign, he may do so by he will have to send the notice in writing to the central government. However, as per section 416, such President, Chairperson or the member shall continue to hold office until, there are again certain conditions, until the expiry of 3 months from the date of receipt of such notice by the central government, or a person duly appointed as his successor enters upon his office, or his term of the office comes to an end, or out of above mentioned whichever is earliest becomes applicable in that particular situation. Now let us discuss how these members can be removed. Section 417 provides for removal of the members. The central government may order for removal of any of the persons appointed under earlier sections which we have just discussed after consultation with Chief Justice of India in the following cases. If he has been adjudged as an insolvent or has been convicted for an offence which, in the opinion of the central government, involves moral turpitude, or has become physically or mentally incapable of acting, in such cases the President, the Chairperson or the member, or has acquired such financial or other interest as is likely to affect prejudicially his functions as such President, the Chairperson or the member, or has so abused his position as to render his continuance in office prejudicial to the public interest. Further, the proviso to the section is also there which states that except for the extra reason mentioned under clauses A, the removal on any other ground would require reasonable opportunity of being heard. A removal may be effected by the central government in case of proved misbehavior, or if the situation is of any incapacity where inquiry has been made by a judge of the Supreme Court. Such person must have been informed of the charges against him, and he should be given a reasonable opportunity of being heard in accordance with the principles of natural justice, although he may be suspended during the period of inquiry. Now it's a time to discuss orders of the tribunal and how the appeal can be filed. The provisions which are necessary here are sections 420 to 423. After giving a reasonable opportunity to the parties of being heard, the tribunal may pass appropriate orders. The tribunal, within 2 years from the date of the order, may rectify mistakes in its orders. No amendment, however, can be made to an order against which an appeal has been preferred. The copy of every order shall be sent to the concerned parties. Further, the appeal may be preferred before the appellate tribunal against any order of the tribunal by any aggrieved within a period of 45 days. From this date, we have to count from the date on which the copy of the order of the tribunal is made available to the aggrieved person. Section 421 subsection 1 states this. And if any order is passed by the tribunal with the consent of the parties, no appeal shall lie against any such order to the appellate tribunal. The appeal to the appellate tribunal shall be in such form and accompanied by such fees as may be prescribed. In case the appellate tribunal is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the period of limitation of 45 days, the appellate tribunal may condone the delay in filing of appeal but not exceeding 45 days after the expiry of period of limitation of 45 days and entertain the appeal after expiry of said period of 45 days. On receipt of appeal, the appellate tribunal shall provide a reasonable opportunity of hearing to the parties to the appeal, and after hearing the parties to the appeal shall pass such orders thereby confirming, modifying or setting aside the order which has been appealed against as it thinks fit, and send a copy of every order made by it to the tribunal as well as to the parties to the appeal. Further, we can see section 422 provides that every application has to be dealt with and disposed of as expeditiously as possible. As far as possible, it should be disposed of. The time frame which has been provided here, you can note that it is within 3 months. Where such disposal is not done, reasons for not doing so should be recorded in writing. After taking into account such reasons, the president or the chairperson may allow a further period of 90 days for disposal. Anybody who is aggrieved by any order of the appellate tribunal may file an appeal to the Supreme Court within 60 days from the receipt of the order of the appellate tribunal to him. It should involve a question of law. The period may further be extended by another set of 60 days, and it should specify a sufficient cause. Now it's a time to discuss procedure which is being followed by the tribunal and appellate tribunal. Section 424 of the Companies Act 2013 provides for it. The tribunals shall not be bound by the procedure as has been laid down by the Civil Procedure Code 1908, but guided by the principles of natural justice. This is very important provision here. These have the powers to regulate their own procedure. For the purpose of discharging their functions under the Act, the tribunals shall have the same powers as are vested in a civil court while trying a suit with respect to the following. I am just narrating the instances: summoning and enforcing the attendance of any person and examining him on oath, requiring the discovery and production of documents, receiving evidence on affidavit, subject to the provisions of sections 123 and 124 of the Evidence Act 1872, requisitioning any public record or document or a copy of such record or document from any office, issuing commissions for the examination of witnesses or documents, dismissing a representation for default or deciding it ex parte, setting aside any order of dismissal of any representation for default or any order passed by it, any other matter as may be prescribed. The orders of the tribunals are enforceable in the same manner as a decree of the court. In the case of a company, the order will be sent for enforcement to the court in whose local limits the office of the company is situated. If the order is against an individual, the order is to be sent to the court in whose local limits the individual resides or carries on business or professionally works for gain. About the proceedings before the said tribunals are deemed to be judicial proceedings within the meaning of sections 193 and 228 of the Indian Penal Code 1860 and for the purposes of sections 198 of the IPC. These are to be deemed to be civil courts for the purposes of sections 195 and chapter 26 of the Criminal Procedure Code 1908. These tribunals shall have the power to punish those who commit contempt of tribunals. Further, the tribunals have limited power of delegation of their powers. The president, members and officers are deemed to be public servants by virtue of the provisions which has been provided under section 427, and they are not to be punished for any action which has been taken in good faith. Section 428 provides for it. Further, section 429 provides for the powers to seek assistance of chief metropolitan magistrates, while section 430 provides that due to the extent of powers vested in the tribunal, no civil court would have any jurisdiction. This is again a very relevant provision. Any vacancy in the tribunal shall not invalidate any acts or proceedings by virtue of section 431. Section 432 confers the right to legal representation upon the parties. Regarding limitation, section 433 prescribes that the provision of the Limitation Act 1963 are, as far as possible, would apply to the proceedings or the appeals before the tribunals. The proceedings before the said tribunals are deemed to be judicial proceedings within the meaning of sections 193 and section 228 of the Indian Penal Code, and also for the purposes of section 198 of IPC. These are to be deemed to be civil courts for the purposes of section 195 as well as chapter 26 of the Criminal Procedure Code 1908. The tribunals have the power to punish those who commit contempt of the tribunals. This has been stated under section 425. Section 425 provides that the tribunal and the appellate tribunal shall have the same jurisdiction, powers and authority in respect of contempt of themselves as the High Court has and may exercise for this purpose the powers under the provisions of the Contempt of Courts Act 1971, which shall have the effect subject to modifications, which can be that the reference to a High Court shall be construed as including a reference to the tribunal and the appellate tribunal. The reference to Advocate General under section 15 of the said Act shall be construed as a reference to such law officers as the central government may specify. Now, let us talk about the delegation of powers, the powers which are vested with the tribunals. The tribunal or appellate tribunal may, by general or special order, direct subject to certain conditions, if there may be, as specified in the order, any of its officers or employees or any other person who has been authorized by it to inquire into the matters connected with any proceeding or, as the case may be, appeal before it and to report it in such manner as may be specified in the order. Further, section 427 and section 428 state that the president, members and the officers are deemed to be public servants within the meaning of section 21 of the Indian Penal Code as stated under, as we have seen under section 427, and they should not be punished for any action taken in good faith. This is stated in section 428. Section 429 provides for the power to seek assistance of chief metropolitan magistrates. It states that the tribunal may, in any proceeding relating to a sick company or winding up of any other company, in order to take into custody or under its control all property, bank of accounts or other documents, request in writing to the CMM, that is Chief Metropolitan Magistrate, Chief Judicial Magistrate or the District Controller within whose jurisdiction any such property, books of accounts or other documents of such sick company are situated or found to take possession thereof. Such officers may take possession of such property, books of accounts or other documents and cause to be entrusted to the tribunal or other person authorized by it. Here we can see that for the purpose of securing compliance with the provisions of all of the provisions as we have just discussed, the CMM, CJM or the DC may take such steps and use such force as may in his opinion is necessary. No act of the CMM, that is Chief Metropolitan Magistrate, Chief Judicial Magistrate or the District Controller done in pursuance of this section shall be called in question in any court or before any authority on any ground whatsoever. Section 430 provides that to the extent of powers vested in the tribunal, no civil court would have any jurisdiction. Moreover, any vacancy in the tribunal shall not invalidate any acts or proceedings by virtue of Section 431. Section 432 confers the right to legal representation upon the parties. If we talk about limitation, Section 433 prescribes that the provisions of the Limitation Act 1963 are, as far as possible, would apply to the proceedings or if we talk about the appeals before the tribunals. Transfer of proceedings has been mentioned under Section 434. Now let us see what are the outcomes of today's module. In this module, we have discussed many things about tribunals as has been provided under the Companies Act 2013. Especially, we have learnt about these quasi-judicial authorities. Then we have tried to understand how this tribunal is constituted, how the members are selected and how the members can be removed from their respective positions. We have also looked into the details of their salary and the term of the service. We have also tried to find the prescribed procedure as per the Companies Act 2013 and what can be the time for filing of appeal before Appellate Tribunal and the Supreme Court. We have also known at the end of this module how the orders are being passed by these tribunals and how this act is effective in expeditious disposal of the applications. Thank you.